Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. In every episode, we'll hear from other attorneys, accountants, and other professionals who can impact the success of your litigation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to another episode of Time is Not on Your Side. I'm Rob Eckard, board-certified business litigation attorney, where we bring you topics and interesting areas in one platform. Today's topic is going to be a former judge's perspective and the tips and strategies to maximize mediation and arbitration. I'm really pleased to announce our guest today, retired circuit court judge from the state of Florida, Jack St. Arnold. Good morning, Jack.
Good morning, Rob.
Let me tell our viewers and our listeners a little bit about you, Jack. You are a retired circuit judge where you spent, it looks like about 17 years on the circuit court bench here in the 6th Judicial Circuit in Pinellas County. You grew up in the Tampa Bay area where you had an interest in airplanes and airports. You made your first solo flight on your 16th birthday. I love learning these things about guests. That's pretty amazing. You further pursued pilot ratings as the age permitted. You were a student at the University of South Florida, and you supported yourself through that time as a flight instructor. These things I only learned because of these interviews. You earned your Bachelor of Science degree in finance. You obtained your Juris Doctorate, I believe, from Hamline University up in Minnesota in 1976. That was a good year, the Revolutionary celebration, right? All kinds of parades. You thought they were for you. You entered private practice before becoming a circuit court judge in 2003, where you presided over pretty much every division: felony, family, probate, the appellate divisions. And in 2016, you were recognized and received the William Castagna Award of Judicial Excellence by the Barney Masterson's Inns of Court. And that's quite an award. I think I was on the Inns of Court that year. And now you retired and you serve as a mediator, arbitrator, and special master. As a civic leader, Jack served on numerous boards, committees, and task forces, including serving as a Dunedin City Commissioner for two terms, a graduate of Leadership Pinellas, Leadership Tampa Bay, Leadership Florida, past member of the National Leadership Training Council. And you and your wife, Nancy, enjoy traveling around the world, and this amazed me. You've been to over 100 countries.
Yes.
That's amazing. You went to St. Petersburg College, got your AA there, USF degree in finance in 73. We said you graduated from Hamline, diploma of judicial skills in the Academy of Judicial Education. You've been admitted to the Florida Supreme Court and looks like all the federal courts and courts of appeals in the United States Supreme Court, and you are a Florida Supreme Court certified mediator. Wow. You know what? If I continue to go, Jack, we wouldn't have any time for questions and answers. You got like 10 pages here of your accomplishments.
Well, it just means I'm old.
Well, let's jump in today because I know there's a lot of viewers on here, whether they be lawyers or whether they be lay people or they be law students or students in general. The topic is interesting today. So let me ask you right from the beginning here. For those folks that are listening that may not know, what is the difference between mediation and arbitration? And how does the role of the mediator or the arbitrator judge differ from one another?
The difference is huge, Rob. Mediation, the clients decide. I tell them right up front, this is not a trial. I'm not going to try your case. I'm done trying cases. Today, we're going to have a search for solutions. We're going to brainstorm a way to fix the problem. Setting aside what the law is, what's the problem, how are we going to make it work? We can customize the solution. the parties can actually agree to do something that the court can't order them to do. I've had several instances where one side will say, well, I can go to my brother-in-law and borrow some money, and that kind of makes the whole solution come around. The judge can't order you or your brother-in-law to lend money. So it's more widespread in the area of solution search. Arbitration, the difference there is I decide, and it can either be me or a panel of three, but we do make a decision. Now, it's usually a non-binding award, although it can be binding. If you have a contractual term that says it must be arbitration, then it most likely is binding. You can agree to make it binding. So it is the arbitrators that make the decision. It's sort of like a non-jury trial in that each side presents their evidence. It's usually done by proffers. Typically, there's not testimony given and that sort of thing. Each side goes in there and basically says, if I go to court, this is what I'm going to show and this is why. And we hear arguments on both sides. The advantage to arbitration is that it gives an independent look by a third party at how your case looks. Sometimes attorneys get so involved with these things, they really can't see the blemishes in their court, in their particular case. As to one or three arbitrators, that's usually up to the parties.
Let me ask you this. In terms of the arbitration proceedings, when you sit either as a sole arbitrator or on a panel, in your experience, and you indicated that most of the time this is done through proffered testimony, have you seen the proceeding, the arbitration proceeding, where the directs are proffered and then there's live cross-exam, if that helps in arbitration?
Yeah, generally not, because the big drawback to arbitration is you can't judge credibility. The attorneys just say, this is what my guy's going to say, this is what I'm going to cross him with, although they usually don't let the cat out of the bag at that point in the proceeding. They just say what their case is going to be, and you have to kind of decide from there.
What do you think about in terms of the cost benefit analysis, or the cost in general, between mediation and arbitration? And when I say cost, I mean cost to the parties, right? I mean, that's ultimately who's going to bear the cost.
Absolutely. If you get three arbitrators up there, that gets pretty expensive pretty quickly. As far as the mediation goes, the client has much more control over what the outcome is. I tell them up front, nothing's going to happen here that you don't agree to. You're not going to like it. I'll guarantee you that right up front. It's like filling out your tax return. You don't like it, but you agree to do it because you don't really have any other choice, and you can see how it's going to come out.
Well, Jack, not everybody has the amount of money you do, so they don't like you don't like filling out your tax returns. I know, but it's something you got to do. Well, let me ask you this: so, what are the 2 or 3 mistakes you see attorneys making in mediation?
Not being prepared, not making their client prepared. It's been my experience. Sometimes you get in there, and I tell them right up front that you're going to be here to make some difficult decisions. They should be prepared for that. Many times we'll come up and say, okay, this is where the case is coming down here. This is how the facts look. These are really your options as they've been presented today. What do you want to do? And they look at you like, gee, I don't know. Well, they should be prepared to make a tough decision. Have everybody there that is going to be necessary to make a decision. I emphasize that they should not pre-decide it. Many times at mediation, things look a little differently after you hear from the other side. Other points are brought up. The mediation presses you. The mediator presses you on it. Well, how are you going to prove this? How are you going to get that evidence in? Where are these facts in your case? Well, gee, they're not really there. So you have that. The other ones that are most irritating are the ones that just want to get past mediation. We want our impasse so we can take it to the judge and get our trial date. Well, why? I mean, so you can make more money? The outcomes are still the same. The options are still on the table. Maybe there's something you hadn't considered, but that's probably one of the bigger mistakes you see. They just come in with a fixed opinion, and they're not willing to listen to anything.
You bring up a couple good points, and so let me dissect what you said a little bit further. First, for my practice, particularly in commercial litigation, business litigation, we always prepare a mediation a mediation brief, confidential brief to provide to the mediator. And I know most lawyers do that. Do you see times where you don't get anything from a counsel that's going to mediate?
Unfortunately, that's the case. The best I can do is go look at the docket, read the pleadings, check the motions, and that sort of thing. One of the mistakes I do see is that there's really been no discovery. I don't mind an early mediation, but everybody realizes we don't have discovery, and don't tell me when it's time to make that tough decision. Well, gee, I don't have whatever it is that I need. The other ones that I see, they come in with a pending motion for summary judgment. Well, if you really believe in your MSJ, get it ruled on, because there's no sense in us sitting here guessing, trying to settle the case with that pending. So the biggest thing is to know your case. Frequently, I'll ask people, okay, I don't usually ask in personal injury cases what your damages are, because I know the answer. It's whatever the limits of the policy are. Well, let's go at it the other way. How are you adding these up? Let me take these down. What numbers are you putting in there? And then it falls way short of their demand. Like, how am I supposed to sell that?
Right. So the calculus is not anchored to anything. It's this pie in the sky, right?
Exactly. Or they really don't have a number. You know, it's in some of these commercial cases. If you have maybe a contract where you're not allowed to compete and non-compete, there's some business damages. Well, what are they? You know, did you really lose any customers? Oh yeah, lots of them. Name 3. Well, I can't. How are we going to sell that? So that's part of the preparation, not only for the attorney, but for the client as well.
Yeah, the calculus of damages is, I always think of that as in cases I have where you get these, I do mostly defense, but cases where we even do plaintiff's work where you see the lawsuit's been filed and you reach out to the other side and you say, all right, well, what are you looking for? I'm not really, other than the jurisdictional allegation in the complaint, what is it that you're looking for and how you're calculating the damage? And you get the, well, I don't know yet. And I hate when you see someone shooting and then aiming second, so to speak. I like to go into my cases knowing what our damages are and how we're calculating them. And certainly, especially, non-competes, although that's subject to another podcast probably, because the FTC has now sent or proposed a ban on them. But one of the things is in the non-competition arena, and you've addressed it. Well, we've lost customers. Well, but for this infringing conduct or this competition, would these customers have stayed with you anyway? So we get into speculation damages, right? And no court's going to award those. So you bring up those good points. But so for you as a mediator, it's helpful to have a mediation statement or brief provided in advance.
Yes, it saves me time, saves your client some money. The other thing that would be good for the attorneys to know is that you can use the mediator. I can be more forceful with your client than you can. He's paying you. He doesn't want to think that you've turned against him. I don't have that restriction on there. So I can support you. I very much enjoy it when I get in there and I talk to them very, very bluntly. And then when I leave the room, the attorney says, see, I told you. It builds your credibility with your client, and I'm happy to work with the attorneys on that.
Well, that really separates the wheat from the chaff with good mediators, good, credible, reputable mediators. And I've had some ones in the past that just don't have that level of control or ability to do what you just explained. So that is a huge benefit for clients that need to hear it from especially a former judge. With that maybe the case isn't what they thought it was, notwithstanding their beliefs. Selecting the mediator. I know you should be selected in every single case because you're incredible. Looking at it from a litigant standpoint, when going to determine and select the mediator, because we know that there's a lot of mediators out there. How important is it to select the right mediator?
I think it's pretty important. And no, I'm not the right one in every case. You have to make that decision based upon your client. If you have a case that's emotionally charged, an emotionally fragile client, maybe I'm not the best guy because I am going to be blunt. Here's the facts. This is what the judge is going to see. These are the options that are on the table. Which one do you want me to work you toward? It's pretty straightforward. Some of them, family lawyers, you get into some very emotional areas. Probate. You get two sisters fighting each other over grandma's estate. It can get nasty. So you want people that have the empathy or the ability to talk to your client. If your client is a hard-nosed businessman, he understands numbers, understands facts, I work best with those. If it's an argument that it's just not fair and I want them punished, you try to explain the court just doesn't have one of those machines sitting behind it that fixes hurt feelings. It's just not coming.
So those are great tips. So you would also agree that because a lot of lawyers, not just judges, but a lot of lawyers, of course, are mediating, and some very good ones out there. In terms of selecting the right mediator, you indicated that is important to get hopefully the mediation result, to make it effective. So obviously, if you have a family law case and you're selecting a mediator that's really a commercial litigator, that might not be the right mediator. I mean, given you're a former judge, have sat in the courthouse across all those disciplines. It's different, but certain mediators are more along the lines of commercial litigators, and may not want them to mediate your family law case. Would that be fair?
Yeah, we get into they're basically business divorces. You got two partners breaking up. You want a mediator that understands business, that can read a financial statement, and is tuned in to business-related issues. If it's a situation where it's a family case and there's custody and children involved and other miscellaneous violence issues, you probably need someone that's more in tune with that sort of thing and knows where public services may be available. As far as selecting the mediators, if you're one of the guys that wants to just go in and get your impasse so you can get your trial date, pick the cheapest one you can find. That's my advice.
Do you think that? Do you think when that happens, then there's really, you're supposed to come into mediation and engage in mediation in good faith, right? I mean, you see when that happens, where a lawyer comes in and says, listen, we got to do this. We got an order to do it, and we're going to do it, but let's make it quick. I mean, it doesn't that tell you something right from the start?
It does. I had one mediation with a very, very, very large PI firm, and the very young attorney announced at the very beginning that we have no intention of settling this. I called it off. I said, there's going to be no mediation. I sent in a notice of non-mediation. It just isn't fair if you go in there with that attitude. You're right. It should be good faith. You know what? You might learn something. There might be a different point of view that you hadn't really considered or appreciated. And I guess finally, sometimes in these PI cases, it is still the client's case. It doesn't belong to the lawyer, despite the fact that 40% of it's yours. It belongs to the client, so they ought to have a say in it.
No, good point on that. What is your experience for purposes of, when COVID hit, we had everything virtual, and of course we're doing virtual now, but the pros and cons of both virtual mediation and in-person mediation?
I rely on the attorney to make that call for me. They know the clients. In-person ones, it's much easier for me to bond with each side as we're talking to, especially during breaks. You're sitting around having a cup of coffee and a donut, and you can talk about something totally unrelated, and you build a little trust. In person, you can get a lot from body language and reactions and that sort of thing. Are they paying attention? Are they really involved? Are they overly emotional about it? Sometimes, though, in mediations, people just can't face each other. That's where the virtual comes in a little bit better. They feel a little bit more relaxed. I think in a face-to-face, I can bring more pressure on them. You lean across the table and just stare at them and let silence do the work for you. Like you got to decide that there's no way out of this, laying out the facts and that sort of thing. Problem with Zoom is you don't always know who's there. There's your best poker buddy or your bartender in the background, signaling to you yes, no, and what the answers are. I've had people driving their car around town. Since I've adopted the position, if you're in a car, we're not having a mediation. Hang up. We'll talk about it when you have time to focus on it. Sometimes on Zooms, you get distractions, the dog's barking and that kind of thing, but that can be sometimes handled. The other problem I have with Zoom is many times the client will be sitting with the attorney, and that's good. However, once in a while, I want to separate the attorney and talk to them and get a little more guidance. Is this going where you want it to go? How do I support you? What can I do to help you bring this to a soft landing? And with the client sitting there, I've asked them to go take a walk, and I want to talk to your lawyer, but that's not always as easy as it is just moving to another room.
Certainly,
the final thought is, inability to do Zoom. Sometimes you get folks that, like me, are just not all that dialed into how these things work, and you have a little problem staying online.
Yeah, I prefer in person if we can do it in person, like any other court hearing, unless it's going to be a 5-minute hearing. I remember having a case in Lower Manhattan, 60 Center Street. It spun off a federal case, and the judge would call a hearing, status hearing. This was pre-COVID at 4:30, on a Friday. And being the only out-of-state lawyer, I'd have to catch a flight in the morning or the night before up to LaGuardia or JFK, and stay over, get down to 60 Center Street by 4:00 for a hearing, and then, of course, leave the hearing at 5:00 and try to get a cab out to one of the airports, which is almost impossible. But the client's got to pay for a 10, 15-hour day for a 30-minute hearing. But similarly, in virtual mediation, right, it's much more convenient no matter where the parties may be located, right, for one. But again, I think that in-person discipline, and you're there and you're not distracted, you're here to do this and settle it, hopefully, and you intend to do so, forces folks to, focus on the issue and not, because you don't know what's going on out there.
Right.
Let me ask you this. Let me ask you about, if you can give me a percentage, how many cases that you have sat as a mediator or worked as a mediator, do you see people waiving an opening in the mediation?
That's probably the rule. Breaking it down by categories, that's almost always the case in family, generally in probate, anywhere where there's emotion involved. Sometimes in the corporate divorces, they waive it. Personal injury, a high percentage want to do the opening, generally for two reasons. One, they want to impress their client. Secondly, it's their first shot at really talking to an insurance representative to get their case across. So in those, you pretty much have to let it happen. Doesn't work as well in some of the emotional ones, and in some of the high conflict ones, they come in and say, we don't want to do it. Please don't. So I work for you guys. If that's the way they want to do it, that's fine. It's their mediation. We'll do it the way you want. It's not always that helpful. I think everybody in most of these cases know what it's all about, and they're ready to go forward. The emotional ones, in addition to the probate and the family ones, can be surprisingly condominium fights. You get two associations or a resident against the association, and it can get pretty bitter. And finally, whatever they want to tell me, I can get in the breakout room. So openings are not all that helpful, but if you want to do it, I let you.
Yeah, I mean, I early on in my legal career, I was big on openings, and having been a former prosecutor, you just do your opening, but I came to learn that, if it's such a charged emotional opening kind of attack, or if you will, I mean, there's certainly no rules of evidence in an opening mediation, but you find after the breakout session that the other side, or maybe your client, after the opening is given, you're peeling your client, or the other side's peeling their client off the wall for the next 2 hours because they're so pissed off about what they heard, right? So most times I agree with you that the party should know, the lawyer should know what the case is about, and probably, like you said, the emotional issue can only kind of throw gas on the fire, so to speak.
Most of the time, what I do when I go to a room is for my first visit, I just say, "What do you want to tell me?" and let the client get it off their chest. They feel like they've had their day in the court. They've had an opportunity to have everything said. You can almost guess at what it's going to be, but you let them do it for that reason, and they go forward from there.
One of the things that I really look for in a mediator to mediate again for me is all of the things you've discussed, but certainly when there's what looks to be coming to a point of impasse, and to have a mediator that's not dissuaded and says, okay, it doesn't look like we're going to get much farther, or we're not, what is your feeling in terms of what do you do? I know every case is different, but what do you do when it looks like you're going to hit an impasse to try to keep it moving forward?
Well, from the mediator standpoint, that's when mediation really starts. Now we've got everybody solidly locked down and they're nowhere near each other. What I try to do is move them away from their positions. Let's talk about what's the judge likely to do with this? Not what you want, not what they want, but this is what the judge is going to hear. And based on that, by the way, I know your judge. He was 2 doors down from me. We had lunch every week. This is, perhaps some of the things that the judge is going to see. Or if it's a jury, we got 6 little old ladies from the trailer park and they're going to hear this case. Where do you think they're going to come out? That's what we're really guessing about here. Not what you want or what your client wants and so forth. It's what are you going to get at the other end? After we go around that bush and talk about it for a while, the next thing is, as they harden their position, I don't care, I want to go to trial. Oh, okay, well, what's a trial budget look like for you? It amazes me how they've never considered that. Even the attorney, and I'll put them on the spot. I'll say, okay, you're not going to be held to this. This is not binding, but your client is entitled to have some idea what he's getting ready to spend. Is it 20, 25,000? We got another 10 for experts. Is that kind of the neighborhood he's looking in? And, they usually come up with a bracket. Then I look at the client and say, okay, I understand what you're saying. Get your checkbook out and write a $35,000 check and give it to the attorney. And by God, we'll go see what those 6 little ladies from the trailer park think.
Right. Yeah. And I always love to hear, I'm being facetious, but the client that comes in and says, I don't care how much it costs. I'd rather pay you than pay the other side. And of course, they start getting those bills and they start realizing this is not fun. And you just bring the point home that now we're at mediation. We can settle this. Those costs, those expenses that you're going to incur, those are going to happen. And it may be more. And those are, now is the time, maybe put it towards a resolution. But those are really good points for a strategy to try to move the impasse away from that inability to focus on getting it done.
The one thing I do at that point, if there's still, I'm going to go forward, everything else, I kind of spread this out a little bit. You seem angry. You seem, really committed to going forward with this. You're going to take it to trial. Yeah. Well, tell me this. How are you going to feel if you lose? How are you going to feel if you have to pay the other guy's attorney under some proposal for settlement? Explain that to him. Is that going to affect you emotionally? So
yeah,
and have we talked about appeals yet? What do you think an appeal costs if it doesn't go well for us, or if it does and they appeal? Try to pump economic reality into it as best I can.
Yeah, that's important. I think any good lawyer that represents their client needs to certainly address that issue throughout the case. What do you think about the following statement? The best way to avoid a trial is to prepare as if you're going to trial.
I think that's accurate. You should certainly understand your case to the extent that you're going to have to put it on, because I will ask you, how are you going to get that evidence in? How's the jury going to see that sort of thing? But if you're doing that, be careful not to overlook creative solutions. Back to the beginning of the mediation, where we can come up with some customized solutions that the judge or the jury could not order. Have we really considered those? Don't overlook some of the emotional hot buttons. I've done some probate cases where we'll have one side living in grandma's house and doesn't want to move. The other side wants their money out of it. I think we can find a solution to that. What if you did keep the house and they got the bank account or whatever, and start doing some dividing up like that. So find out exactly who needs what, some trade-offs and that sort of thing in family cases. I also tell the client, look, I know you're enjoying this process. You're having a great time with your attorney. You enjoy getting stuff from him in the mail. This can all be over with today. We can end it now. Would you like that? And if they're calm, they usually, I'm not enjoying this. This is no fun.
No, it's, you get litigation fatigue, right? I mean, it's exhausting, and I get it. And
we call it litigation therapy.
I've got to make a living too. But the reality is, it's exhausting. And you can see the toll it takes on folks. And I think, a good mediator will help them get to a point where maybe it's time to, button it up. Of all the things you've done and all the cases you've been part of, and you're almost 20 years as a judge and now a mediator for some 4 or 5 years after leaving the bench, you have any cases that stick out to you that you were involved in, either as a judge or mediator, that some words of wisdom on those cases of any sort?
I've got a few when I was on the bench that, particularly in the family division. There was one in the probate division. I look back on and think, did I really do the right thing? And those kind of bother me. They stick with me after a while. On the mediation ones, I enjoy settling them. I feel like I've done a good job. I like calling the judge afterwards saying it went away. You don't have to worry about it. The ones that I don't settle, I'll stay up at night thinking, geez, if I'd have just said this or just said that. I don't have anything else to add to what I've already told you as far as words of wisdom. I don't know that I have any, but I really believe in the mediation process.
Well, you touched on a point. I want to just go back to it real quick. Even if there's an impasse, I know you've said this in the past, that just because we impasse doesn't mean we can't still try to get this done, right? I mean, that's always an option, right?
I have called people up the next day and say, look, I don't have authority for this, but if I brought you X in an offer, would you be interested? And having let a little time go by, sometimes, I would probably consider that. Then you go to the other one and say, if you offered Y, and see if you can pull it together if there's a real chance of doing it.
Let me try to jog your memory, and I'm not going to mention any names, parties, or case numbers, but a lawyer that knew you were going to be on my podcast today called me with a very funny story that you were the judge on, and I believe it was a family law case. And if it jogs your memory, hopefully I'll get a chuckle out of it, because my understanding was there was a woman that represented herself. She was Russian, and she was a former adult stripper, Russian, I guess. And then she became a CPA. And then she decided, and she was representing herself in the case in front of you, and decided that she was, capable of doing so, and ended up wanting to go to law school. But apparently there was adverse rulings against her. And I was told by this lawyer that the Russian stripper CPA said, "Who's your supervisor? I want to know who your supervisor is." I thought that was a funny story. I don't know how Judge Jack responded.
I don't recall that. That sounds like one I would remember.
No, I thought that was a funny story, but it's funny the stories that will remain in some lawyers' heads. That, of course, you see thousands and thousands of cases, right? But we live with these things, and but we all got a chuckle out of that. Kind of wrapping things up here, and I want to get back to some lighter side of the show. I'm still amazed at the fact, and I didn't know this until today, that you've been to over 100 countries. I mean, what are there, 190, 180?
Yeah, something like that. If you go by the how many members there are of the United Nations, there's a few that you can't go to and wouldn't want to, but I've tried to see a little bit of the world and certainly enjoyed it. Just came back from Vietnam. We leave Wednesday for Northern Ireland. I'm going to do. We got a small boat with 18 cabins that goes from Dubrovnik to Split. We're going to do that in September, and then the end of the year, the wife wants to go to Rwanda to see the gorillas. So,
wow. I mean, I always say travel is life, and I'll tell you, my mental energy and my stress levels seem to be lowered knowing I have a trip planned somewhere.
Yes, absolutely.
Tell me, given the fact that traveling is just an amazing thing, and I think Ronald Reagan said it best when he talked about people to people contact, even with the Soviet Union, would be something that would be beneficial. I mean, I've been to Cuba so many times, and I've written white papers on doing business in Cuba and protecting intellectual property rights in Cuba. And initially people say, aren't you scared to go there? And I remember back in the day, the Cold War and all that kind of stuff. But Vietnam was a communist country, and you just got back from there, right? I mean, you said it was an amazing experience.
Yeah, I do get that comment. I tell them where I'm going in South America. They say, is that dangerous? And I say, well, you do fly through Miami.
Well, I tell them that's why I go to Bogota or Medellin or Cali, Colombia. That's Mr. Danger, Mr. Danger. So exactly. Give me the top 3 countries that you've been to that are your favorite. I don't want to pick one because I know that's sometimes hard. Give me the top 3 that you say are just amazing places.
I really enjoyed Tasmania, the people there and the sights and so forth. That was pretty amazing. My top one is probably down in Patagonia, around there in Ushuaia and Tierra del Fuego. That was pretty amazing place to visit. And I really enjoyed Vietnam. The history that we have with Vietnam is very much history now. Most of the people that you run into were born since the Americans left. It's a totally different country now, different people. It's amazing, Rob. You go to Hanoi, you don't see men our age, and we killed them all. So it's a totally new generation. They're always happy to see you. Very inexpensive by American standards, and just beautiful, gorgeous country.
So, given the Vietnam conflict, Vietnam War was a very hard time in this country, and certainly the withdrawal from Vietnam. You see the pictures of which was the fall of Saigon. But you've been there just recently. Is the exchange with the people? They like Americans, or?
Oh yeah, they very much. In fact, I sat down with several friends and had lunch with 3 former Viet Cong, and they gave us their perspective, and they basically said, you guys were pretty good. And he said, we got our licks in every now and then, but that was a different time. There's something cathartic about sitting with your former enemy and visiting them. Both sides of the issue. Our tour guide, we drive down the road, he pointed out a house. He said, that's where I grew up. That was our house. And then after the North came in, they came by one day with some paperwork and said, we think you would like to donate your home to the party. Sign here. And that was it.
Amazing. I tell you, traveling also makes you really appreciate what we have here, right? In the United States. As fractured as our country is right now, it really does make. I come back and I see the stars and stripes, and it just gives me a comforting feeling.
Yeah, you can talk to the police, you can say what you want about the government, and there's no repercussions. That is so foreign to those people. They wouldn't anymore think of doing that than going to prison.
I went to Russia with Judge Kavakovich from the federal courts and 5 or 6 other judges back in 2004, which was, I think, 13 years after the wall fell. And we were trying to promote democracy and the rule of law there. And, it's just amazing just to go to a country that is just, the democracy is just starting, or supposed to be starting, or what we see they have compared to what we are. And, I know the concept. I was talking to some lawyers the other day about, because I practice international law, and the concept of the American judicial system and cross-examination, which we think is the greatest tool for fact-finding, right, and the truth, is kind of foreign in most of the jurisdictions, where the judge does all the questions, and they feel like, hey, don't interfere because the judge knows what to ask. But it's going to traveling gives you certainly that great perspective. So let me ask you, Judge, for as we finish up here, any words of wisdom to maybe lawyers or young lawyers or law students or anybody that you could share, whether it's with the law or life in general, that you would like to impart?
Well, for the law students, I would tell them to consider dental school after they get through this. The young lawyers, it's difficult, learning the skills. Sit in and watch as many skilled attorneys do trials and hearings as you possibly can. I know you've got people that listen to you and watch how you perform, and I think that's an excellent way to go forward. Mediation is a good way to really serve the client, just to solve the problem. You've got a license hanging on your wall that says attorney and counselor at law. Many stop reading with the word attorney. You are a counselor. So let's fix the problem.
Don't lose sight of the human side, right?
Right.
Yeah. Well, right. Judge Jack, wonderful having you. This was a great episode, and I'm sure it's going to be viewed and watched repeatedly, and with folks that can learn a lot, including myself and other lawyers. So I want to thank you today for participating and being on the podcast. I see you or talk to you every so often, but I want to wish you safe travels, because you're always off to somewhere. I'm jealous of you. I live vicariously through you.
Rob, thank you for having me. And if any of your viewers have questions, give me a call. I'm happy to chat with lawyers.
This has been another episode of Time Is Not On Your Side. Please tune in for additional episodes. You can find us on YouTube, LinkedIn, Instagram, and other social media. And remember, victory comes to those who are relentless in their pursuit for greatness. See you next time.
You've been tuning into Time Is Not On Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.